back with another video. We hope we were good companions to you until now. Stay up for that untold, let's discuss knowledge, and subscribe to our channel for some real quality content on untouched and contemporary legal topics. Just like the last few videos, we'll be talking about another rather unconventional topic, that is, aviation law. You heard me right, aviation law. Aviation is one of the most competitive and heavily regulated industries in the world. Today, we have several lawyers practicing this branch of law, and over the years, it has gained a great deal of recognition. Prestigious universities are now offering diploma courses and masters in aviation law. But let's just hang on for a second and start with two simple and basic questions. What is aviation law, and do we really need to have aviation law? Aviation law or air law is a branch of law that deals with flight, air travel, and the legal and business issues that go along with it. The need for aviation law stems from the globalization and expanding nature of human interaction as we move from the seas to the air and beyond our atmosphere. Aviation laws are rules of conduct derived from a widely accepted concept of universal justice, a justice that serves a larger unselfish population and that contributes to peace. Before we proceed, please take a moment to like our video and share it. Also, if you happen to know more about aviation law, do not forget to tell us in the comments below. Let us first start by understanding the history of air law. In the early years of aviation, before World War I, people with foresight had realized that the advent of airplanes added a new dimension to transport which no longer could be contained within strictly national confines. It was for this very reason that at the invitation of France, the first important conference on an international air law code was convened in Paris in 1910. This conference was attended by 18 European states and several basic principles governing aviation were laid down. After World War I, for obvious reasons, the treatment of aviation matters was a subject at the Paris Peace Conference of 1990, and it was therefore entrusted to a special aeronautical commission which had its origin in the Inter-Allied Aviation Committee created in 1970. Around the same time, two British airmen, Alcock and Brown, made the first west-east crossing of the North Atlantic from Newfoundland to Ireland, and the R-34, a British dirigible, made a round trip from Scotland to New York and back. Such events incited many young aviators to propose for an international collaboration in aviation matters post-World War. This proposal was formally taken up by France, and the other principal Allied powers received it favorably. This action resulted in drawing up of the International Air Convention, which was signed by 26 of 32 Allied and associated powers represented at Paris Peace Conference and was ultimately ratified by 38 states. The convention consisted of 43 articles that dealt with all technical, operational, and organizational aspects of civil aviation and also foresaw the creation of an International Commission for Air Navigation or ICANN to monitor developments in civil aviation and to propose measures to states to keep abreast of developments. But what is ICANN? ICANN, or International Commission for Air Navigation, was the forerunner of ICAO. The ICANN first emerged from the International Air Convention, or IAC, of 1919, which on the occasion of the Peace Conference in Paris passed an international aviation agreement that was signed by 26 of the 32 Allied states. We must remember that the United States of America was not a member of the ICANN. The Commission's activities were interrupted by the outbreak of World War II. ICANN then handed the baton to ICAO and retired in 1944, in which the United States of America now participated. Now that we've understood what the history of air law was, let us look at the present scenario. We will first understand the international aviation law and then proceed to understanding the aviation laws of India. To understand the international aviation law well, one must understand that there are international authorities that are present currently, which are ICAO and IATA. Let us start with ICAO. What is ICAO? The International Civil Aviation Organization, or ICAO, came into being on the 4th of April in 1947. In the October of the same year, ICAO became a specialized agency of the United Nations linked to the Economic and Social Council, or ECOSOC. ICAO was created to promote the safe and efficient development of civil aviation. As of 2019, ICAO consisted of 192 out of the 193 United Nations members and the Cook Islands. Now that we have a fair idea of ICAO, let us proceed to understanding what IATA is. The International Air Transport Association, or IATA, is a trade association of the world's airlines founded in 1945. IATA has been described as a cartel ever since. In addition to setting the technical standards for airlines, IATA also organized tariff conferences that served as a forum for price fixing. As of 2016, IATA consisted of a solid 290 airlines, and IATA is headquartered in Canada in the city of Montreal with executive offices in Geneva, Switzerland. Though there are international authorities such as ICAO and IATA to govern airlines and civil aviation, countries do prefer to have their own regulatory bodies. Civil aviation in the United States of America is governed by Federal Aviation Authority. China has Civil Aviation Administration of China. In Japan, civil aviation is governed by Japan Civil Aviation Bureau, and the European Union Safety Agency governs civil aviation in European Union. The Civil Aviation Authority governs civil aviation in, you guessed it right, India. As I told you all earlier, aviation laws are rules of conduct derived from a widely accepted concept of universal justice. These laws are also called conventions. Aviation laws have over 20 conventions, but we will cover the most important conventions in this video. Let us start with the Chicago Convention of 1944, or the Convention on International Civil Aviation. This convention is also called the Magna Carta of Aviation Law. The convention provides for the sovereignty of airspace above the territory of each state, together with 5 freedoms, which were later expanded into 9 by the addition of 4 unofficial freedoms, which govern the freedom of states to operate air transport flights, including the carriage of passengers, cargo, and mail, across, into, and within the airspace of other states. As of March 2019, the Chicago Convention had 193 state parties. Second, the Geneva Convention of 1948. The Geneva Convention, or the Convention on the International Recognition of Rights in Aircraft, signed at Geneva on 19th June 1948, covers rights of property in aircraft, rights to acquire aircraft by purchase coupled with possession of the aircraft, rights to possession of aircraft under leases for 6 months or more, mortgages, hypothecs, and similar rights in aircraft which are contractually created as security for the payment of indebtedness. Third, the Tokyo Convention of 1963. The Convention on Offences and Certain Other Acts Committed on Board Aircraft, commonly called the Tokyo Convention, is an international treaty concluded in Tokyo on the 14th of September 1963. It entered into force on 4th December 1969, and as of 2015, there have been 186 parties which have ratified to it. The convention applies to offences against penal law and to any act jeopardizing the safety of persons or property on board civilian aircraft while in flight and engaged in international air navigation. Fourth, the Hague Convention of 1970. The Convention for the Suppression of Unlawful Seizure of Aircraft, The Hague, was concluded on 16th December 1970. This convention defines the unlawful seizure of aircraft. All the contracting states are required to undertake to make any such offence punishable by severe penalties. Fifth, the Montreal Convention of 1999. The Montreal Convention 1999, or MC99, establishes airline liability in case of death or injury to passengers, as well as in cases of delay, damage, or loss of baggage and cargo. It unifies all the different international treaty regimes covering airline liability that had developed haphazardly since 1929. MC99 is designed to be a single, universal treaty to govern airline liability around the world. Sixth, Cape Town Convention 2001. The Convention on International Interests in Mobile Equipment was concluded in Cape Town on 16th November 2001. The convention was adopted under the joint auspices of ICAO and UNIDROIT. The primary aim of this convention and the protocol is to resolve the problem of obtaining certain and opposable rights to high-value aviation assets, namely airframes, aircraft engines, and helicopters, which, by nature, have no fixed location. As of 16th June 2016, there are 65 parties to the convention. Seventh, the Rome Convention of 1952. The Rome Convention, signed in 1952, addressed the rights of third parties which suffered damage from events involving aircrafts. It entered into force on February 4th, 1958, and as of 2018, there have been 51 states that have ratified it. Owing to time constraints, we have covered only 7 main conventions very briefly. But please note that we've given a link in the description box as well as the references section of our website lawanimated.co.in in regards to all the other conventions. Do check the link out as well as the website for all other information on conventions. That concludes the basics of international aviation law.